Tania Galloni is one of the attorneys for the environmental groups who won what is a landmark decision right here with us at the table today. Great to have you here.
Thank you, Glenna.
Fresh off this landmark case. We're calling it a landmark case because really this is a landmark facility. This has not been done in that way before, which is kind of what you were arguing.
Absolutely. The notion that you can stand up a massive detention center without doing any environmental review, plunk it down in the middle of the Everglades without any consideration for the impacts, it's never been done before, and for good reason.
You know, we have this, our viewers, our audience, we have been talking about this since it opened July 1st, consistently every week. I think we're very well versed in the components of what's going on there. Today, you saw Linny Supal is there. There is no sign yet that she sees of dismantling, of anything coming out. What do you make of that? Should there? It's the weekend. It's Sunday. So
Yes.
what do you make of that?
Well, we know the judge ordered no new construction, or she extended that throughout the preliminary injunction, so we expect not to see construction trucks or any of those types of vehicles that have been going in and out for weeks.
A lot.
A lot
Yeah.
of that type of equipment. We also are hearing reports that the population is now under 400 people and that there were buses going in and out as recently as yesterday. So it's hard to say precisely what is happening, but we know what the judge ordered is no new detainees coming in and a wind down of operations in 60 days.
So the wind down of operations, no new lighting, no new asphalt. We have been out there firsthand watching what goes in, only see what's there when we have an aerial and we can see from the sky what's there. The lawsuit and the hearings, which some of them I've been privileged to sit in on, there's been an argument that the damage is already done. Do you know that evidence-wise?
Certainly some damage has been done, and as long as the center operates, damage continues to be done. So for example, the 24-hour illumination, that's resulting in a loss of habitat to the Florida panther of about 2,000 acres.
Let me just stop you for a moment, because how do we know? I have this mantra, how do we know? How do we know? Because there's so much we don't know, for better or worse.
Sure.
How do we know that?
So expert Randy Kautz, who basically wrote the book on the Florida panther, as the judge acknowledged, he testified that this detention center is in prime panther habitat, prime breeding habitat. It is among the most important habitat there is remaining for the Florida panther. When you have illumination at night, panthers tend to be nocturnal. The research shows that they stay away from those areas. So he calculated that radius outside the facility to amount to about 2,000 acres of loss of panther habitat because they will avoid it. They will not use it.
And that was the nocturnal activities, because obviously there was an airport there, not a hugely active airport, but certainly an active airport daily.
There was a limited training facility there, but even with that, there was panther presence. So we know that there was panther presence when it was the prior use.
And so the very much a part of this lawsuit was the Miccosukee tribe. And in one of the hearings, one of the tribe's witnesses, and I think one of your witnesses too, who had done testing, environmental testing, there was no baseline test, probably because you didn't know what was to come. There was no time to do a baseline. But there has been testing since. Take us through what kind of testing, how often, and if you have the results of water quality and environmental quality, what have you found?
So the baseline issue is because the state gave no notice, right? Gave no notice to anybody, least of all to Miami-Dade County. They just said, we're commandeering this property for this purpose, and then started to deny everybody access to go anywhere near it. So that has been point number one. So there's been limited access to be able to actually get specific testing done. Now the Miccosukee tribe did have a witness that testified that she had undertaken some testing nearby, but we don't know yet what those results are.
No results from that yet. And I think what the Department of Homeland Security attorneys were saying, if we don't have results and we don't have anything to compare them to, how do you know anything's wrong? Is that valid?
Well, they're trying to flip the script, right? Whose obligation?
That's what attorneys do.
Well, they had the obligation to study the impacts before building. They had the obligation to ascertain the baseline, to figure out what the likely impacts would be. Now, they've denied everybody access. They didn't do the study. None of that was done. And even so, our witnesses, and we had about 9 of them altogether, were able to testify to the environmental impacts. The defendants put on one witness who said nothing about the environmental impacts because there's nothing they could say. It's undisputable when you have fencing all around the facility, when you have illumination 24/7, when you have acres of new pavement that is going to cause runoff into these really sensitive wetlands. you can't really argue with that.
And as someone who, I mean, my job is to challenge the narrative. And if we don't have specifics and we can't see and we can't get in, we do see huge wastewater trucks going in and out. Well, what we read and presume to be wastewater trucks is, do you think there's any validity to when the state says, look, we are doing what we need to do to contain the wastewater, you see us shipping it out every day? Is there anything that tells you that the state is doing as much as possible to mitigate the environmental impacts there?
No, again, they had the opportunity to put on evidence to show that this was happening. I think we just heard Maxwell Frost say that he saw silt fencing that was supposed to, be part of this plan falling down, and we all know we've had torrential rains in the last few days. So no, they can say whatever they want. They had an opportunity to put on evidence, and they chose not to, and that's more telling than anything at all.
Let me ask you before I let you go, having been able to sit in the hearing, the governor right off the bat called Judge Williams a hostile judge. Those were his words. I will tell you in a very objective manner, sitting in on federal court hearings, Judge Williams, not so much what she said, but how she said it, did raise eyebrows in the courtroom, challenging the DHS attorneys in a somewhat sarcastic way, and at some point, what someone would call a condescending way. Do you think there's validity to their saying that they just didn't get a fair shake in this courtroom?
I think what you heard was there were lawyers in that courtroom unwilling to answer a basic question. She asked who's in charge of this facility, and you had 4 lawyers for the federal government and 4 lawyers for the State Department who all looked at each other and shrugged. She asked who's the warden? 8 lawyers all looking at each other and shrugged. Now, I don't know any person on the planet who wouldn't have an issue with a lawyer being unable or unwilling to answer a very basic question.
Do we know that yet? Do we know who's in charge yet?
Well, we have reason to believe that we know from filings that they've made in other cases. The federal defendants filed in another case the name of the warden and said they represented the warden. But in Judge Williams' courtroom, they were silent.
Well, by 5 o'clock tomorrow, the state has asked the judge to stop this ruling, essentially, let things go on. So I guess tomorrow we'll know more.
Sounds good.
All right, Tania Galloni, great to have you at the table. Thanks so much for being here.
Thank you so much.